Are LLC members personally liable in bankruptcy? Have you ever wondered what happens to members of a limited liability company during bankruptcy? It's a common question, and understanding the answer can help protect your personal assets. Generally, members of an LLC are not personally liable for the debts of the LLC when it goes bankrupt. The LLC is recognized as a separate legal entity. This means that only the LLC's business assets are at risk during bankruptcy proceedings. Creditors can typically only pursue the LLC's assets to recover debts, leaving members' personal property safe. However, there are some important exceptions to this rule. One key situation is when a member has personally guaranteed a loan or debt of the LLC. In this case, if the LLC defaults, creditors can go after the member's personal assets to recover that loan. So, if you signed a personal guarantee, you could be held responsible for that debt. Another situation is known as piercing the corporate veil. This happens when a court decides to disregard the LLC's separate legal status. If members fail to maintain proper records, mix personal and business funds, or engage in fraudulent activities, they can be held personally liable. It's essential to keep personal and business finances separate to avoid this risk. Additionally, if a member pledges personal assets as collateral for an LLC loan, those assets can be seized if the LLC defaults. This means that if you put your home or car on the line for a business loan, you could lose those assets if the business fails. Members can also face personal liability for certain tax obligations or if they commit fraud or other wrongful acts. It's important to be aware of these risks when operating an LLC. When an LLC files for bankruptcy, it typically does so under business bankruptcy filings like Chapter 7 or Chapter 11. Members usually do not need to file personal bankruptcy unless they have personal liability due to guarantees or other exceptions. If personal liability exists, members may need to file for personal bankruptcy to address those debts. To protect yourself, maintain a clear separation between personal and LLC finances. Keep accurate records and avoid personal guarantees whenever possible. If the LLC is dissolved after bankruptcy, this can also help avoid ongoing fees and obligations. In summary, while LLC members generally enjoy limited liability protection, personal liability can arise under certain conditions. It's wise to consider these factors carefully and consult a legal professional if you are facing bankruptcy with your LLC.